Okay, let's dive right in and translate the notoriously dense concepts of property law into a clear, highly visual architectural blueprint. Look, for anyone tackling the bar exam or managing high-stakes real estate assets, property law can honestly feel like a massive, archaic maze. But today, we're going to completely transform the dryness of that legal text into something you can actually visualize and use. Think of this explainer as a golden skeleton key. We're going to use it to unlock exactly who owns the soil, who controls the future, and who holds those invisible rights to cross the land, laying it all out like a crisp emerald green technical drawing. To keep this from getting overwhelming, we've structured our blueprint into 5 manageable phases: the foundation, conditional additions, temporal pathways, the dead hand, and finally, invisible burdens.
Let's start right at the bedrock. Phase 1, the foundation, which covers present estates.
So the absolute crucial point here is that the fee simple absolute is your ultimate foundation. In American law, this simply means you own the land entirely, forever, with absolutely zero strings attached. When you see legal language like to Alice and her heirs, or honestly today, just to Alice, that creates a fee simple absolute. It's the gold standard, the default building block from which literally all other property interests are assembled.
Think of this totality of ownership like a complete, untouched pie. It mathematically equals 100%. It's the whole shebang. If an owner, or a grantor in legal speak, decides to give away anything less than this complete, perfect structure, the remaining pieces of that pie must logically go somewhere.
And that brings us to phase 2, conditional additions, also known as defeasible fees.
Now, things get really interesting when a grantor gives away property but attaches some incredibly strict strings to it. We call these specific legal building blocks defeasible fees, and they essentially allow a grantor to carve up that ownership pie based on conditional future events. For example, if I deed my land to John so long as he feeds my pets, I've just created a fee simple determinable. John has a present interest, sure, but the very second he stops feeding those pets, his estate is defeated. Because he doesn't hold the whole pie, a future interest is inherently created to account for the rest of it.
If you're gearing up for the bar exam, pay close attention here, because examiners absolutely love to test this specific nuance. Does the property revert automatically, or does the original owner have to actively go take it back? Well, with a fee simple determinable, the property snaps back automatically. Boom. That's the possibility of reverter. But with a fee simple subject to conditions subsequent, you just get a right of re-entry. The original owner actually has to take affirmative action to assert their rights and legally reclaim the property.
All right, moving on to phase 3, temporal pathways, or future interests.
Now, you might be wondering, what exactly is a future interest? It is vital to understand that it isn't something that just mysteriously pops into existence years from now. No, it is a legally protected right that exists right now, today. If I grant a life estate to a tenant, my right to get that property back when they pass away is a future interest. I literally own that right today, even though I can't actually possess the land until tomorrow. Imagine ownership flowing through time like glowing 3D threads on an architectural blueprint. A life estate provides possession only until someone dies, right? And because a life estate obviously doesn't last forever, meaning it's not the whole pie, it absolutely must be followed by a future interest. If the property flows backward to the original grantor, it's called a reversion, but if that thread flows down the timeline to a totally different third party, that's a remainder. When we're mapping out these temporal pathways to third parties, we really have to distinguish between remainders that are a sure thing and those that are just a big maybe. A vested remainder is guaranteed. There are no hurdles left. We know exactly who gets the property. A contingent remainder, however, is conditional. It might depend on an heir being born or someone graduating from college. And guys, it's exactly these maybes that trigger the most feared weapon in all of property law.
Which brings us to phase 4, the dead hand, perpetuities. Take a deep breath for this one.
You know, a law student on a forum once called this the rule against bullshit. And honestly, it hits the nail right on the head. It perfectly captures the law's absolute refusal to let deceased owners pull the strings from beyond the grave forever. Historically, courts realized that letting some aristocratic grandfather lock up land with endless contingencies completely wrecks the marketability of property. We want living, breathing people to buy, sell, and develop land, not be perpetually paralyzed by the dead hand of the past.
So how do we solve this? Well, if you follow this precise, admittedly slightly morbid 4-step process, you can mathematically dismantle any rule against perpetuities problem. First, identify the people alive when the interest is created.
Second, and this is literally how bar prep courses teach it, imagine they all die tomorrow in a fiery crash. Third, fast forward exactly 21 years and 1 day. If there is any logical possibility, no matter how incredibly remote or absurd, that the interest vests on that day or later, the future interest is completely void. It's gone.
And get this, courts will use some truly bizarre legal fictions just to test these boundaries. They will actually assume a fertile octogenarian, an 85-year-old woman, can miraculously give birth to a brand new child who could trigger a property transfer 25 years later. Or take the unborn widow, the theoretical assumption that a currently married man might lose his wife and eventually remarry someone who wasn't even born yet when the original deed was signed. If these wild, crazy scenarios can break your timeline, the grant fails, period.
So 21, that is your golden number. No future interest is valid unless it is guaranteed to vest no later than 21 years after a life in being. Now, sure, many modern states have adopted a wait-and-see approach or even extended this to 90 years by statute, but the classic common law rule of 21 years remains the absolute foundational test of property alienability.
Finally, we reach Phase 5, invisible burdens, easements.
Unlike the foundational present estates we talked about earlier, easements are completely non-possessory. You don't own the dirt, you just get the right to cross over it. Picture glowing green pathways overlaid onto a dark plot map. It might be the right to use a shared gravel driveway, or maybe a public path down to a beach. You don't hold the deed to the soil under your feet, but you absolutely hold a real property interest that legally protects your right to use it.
We've got to classify these invisible pathways, though. An easement to pertinent involves two neighboring parcels. Parcel B, the dominant land, gets the benefit to cross Parcel A, the servient land. This agreement literally runs with the land and transfers automatically to whoever buys the property next. An easement in gross, on the other hand, doesn't attach to a neighboring plot at all. It belongs to a specific person or entity, like a utility company running giant power lines straight through your backyard. So how do these hidden paths actually get carved into our property blueprint? Mostly in 4 ways. They can be explicitly written out in an express grant. They can be implied by how the land was used in the past. They can be created out of sheer necessity because the law flat out refuses to let a piece of land be landlocked without any road access. Or, and this is the most controversial one, by prescription. If someone openly and continuously trespasses across your land for a statutory period of time, they essentially earn a permanent legal right to just keep doing it. Wild, right? On the flip side, clearing these invisible burdens from a title takes some actual legal legwork. You can't just yell out the window and tell someone to stop. You need a formal written release, or the easement must be completely abandoned through a clear, overt action. And no, just not using it for a while doesn't count. Or my personal favorite method, merger. If you simply buy your neighbor's dominant parcel, the easement instantly vanishes. Why? Because you can't hold an easement over your own land. All right, as we wrap up this explainer on the structural overview of property, I want to leave you with a rather provocative question. We've seen how the architecture of ownership allows us to divide up that foundation of a fee simple absolute, how we can attach rigorous conditions and map out legal pathways for future generations. But we also know the law will ruthlessly sever those temporal threads if they stretch too far. So looking at your own assets, how long will your blueprint truly last once the dead hand takes over? Thanks so much for joining me, and keep mastering those foundations.